Hello everyone, I am Sayyam Jain, a legal intern at ubAdvocate. So today in this video I am going to discuss about product liability clause which is present in the Consumer Protection Act 2019. Consumer Protection Act 2019 is the first legislation which clearly defined about product liability law. Before that, in India, there were no specific law which tell about product liability, and its claim under dispute were settled under the legislation like the Sale of Goods Act 1930, the Consumer Protection Act 1986, the Indian Contract Act 1872, and any specific sector law like the Drugs and Cosmetics Act of 1945. Now let's see how the product is defined under the Act. Product means any article, any substance, any raw material which can be either transported as either wholly or in part, but it does not include any human body component. Now that we have understand what is product, now let's see what is product liability under the Act. Product liability is defined as the responsibility of the manufacturer or seller for any harm that is caused to the consumer due to any defect or deficiency that is present in the product or in the service that is provided to the consumer. So now that we have understand what is product and what is product liability in the Act, let's see on whom this liability will be held. Product liability clause will be imposed on product manufacturer, product seller, and service provider. Let's see what is the liability of the product manufacturer. The liability of the product manufacturer is defined under section 84 of the Act. If the product provided by the manufacturer is of lower is there any defect in the product, is there any defect in the design of the product, if the product is not up to the warranty that is provided to the by the manufacturer. Now that we have understand the liability of the product manufacturer, let's see what is the liability of the product seller. The liability of the product seller will be if he exercises sustainable control over the testing, design, labeling of the product which has caused harm to the consumer. If he has alter, modify the product, and after the alteration or modification it has caused harm to the consumer. If he has a control over the assembling, inspecting, or manufacturing. If he failed to exercise inspection or in the assembling or maintaining which cause harm. Now let's see what is the liability of the service provider. The liability of the service provider is defined under section 85 of the Act. It says that if the service did not conform to the terms and condition of the contract, if the service provided was faulty in quality, nature, or manner of the performance, or the service provider did not issue adequate instruction or warning to the consumer which cause harm. But most of the time, the consumer file ill will complain against the manufacturer or service provider in the case where they are not really liable. And to save them from this, there is a provision provided in the Consumer Protection Act that are defenses available against product liability. The product manufacturer will also be not held liable in the case he had not provided adequate information in the following cases. First, that the product was to be used under the guidance of a special expert. Second, at the time of the use of the product, the consumer was under the influence of alcohol or any other drug which are not prescribed by the medical practitioners. If the product was purchased by the employer for use at the workplace and the manufacturer had given warning for the employer. Fourth, that the product that the consumer had purchased was to be used by the another product for their end use, and at the time of the end use the supponent component product was defective, then the product manufacturer will be not held liable. With this, we come to the end of the video. I hope I have made the topic clear to everyone. Thank you.